What you are about to watch is a sentencing hearing for Brittany Abbott, a 36-year-old process server convicted of evidence tampering. Her job was simple: deliver legal documents and certify in court filings that the named individuals had been personally served. Instead, she submitted false proofs of service, describing people she never actually met, including one she claimed had a missing ear. Today, the court will decide her fate. And as you'll see, it does not go as her attorney hoped.
And Mr. Kukuski, we can call your case.
Thank you, Your Honor.
People be Brittany Abbott. I'm here for sentencing on a charge of evidence tampering. It's a 4-year statutory maximum and a guideline range at 0 to 9 months. All right, Mr. Kukuski, anything you want to say on your client's behalf?
Well, Your Honor, I'd just say that I believe Ms. Abbott's going to be successful on the term of delay and the agreement that we've worked out with the prosecutor. It's an interesting case to me in that she gets hired on or is hired on for some firms that are collecting credit card debts, and she's to serve people, and there's not really much training as to how that service is to be done. I think she now understands the ramifications of what had happened. She has expressed to me she's very apologetic to the victims in this case, and sorry that if anything happened with their case, that she's sorry about that. But she did. It wasn't that she just mailed it in, Your Honor, where she said she served somebody, but she didn't. She did drive down from Marquette, go to these residents, although somebody at the residence that she serves, it's not the right person. So again, I think the disposition that's been worked out here is addresses the issues and addresses the conduct and behavior. I would ask the court to follow the agreement that we have for the 6-month delay with Ms. Abbott at this time. Thank you.
The judge isn't buying it. He zeroes in on the most damning detail in the case. Not just that the service was wrong, but that Abbott filed a sworn court document describing a person she claims to have personally served, including a physical detail about a missing ear. That's not a clerical error. That's fabrication.
Well, I wonder about those facts. She filed a proof of service with the court indicating that she had personally served the named people at an address and the location, and included a description of the person, including, it said for one of them, described his appearance, including having a missing ear. So that sure sounds like Miss Abbott is intentionally trying to say, yes, I personally served this named person when she didn't, and not just some sort of technical mistake that she didn't know she could leave it with someone else at the household. So help me square that circle.
Well, Your Honor, there's an application with these firms that she's working with where you just check the box when the paper's delivered. They do the proof of service to the court, and that's the proof of service that was provided to the court. But she was not personally taking those to the court. Again, she accepts her responsibility for the improper service. We're definitely not making any excuses there. It just, that one, Your Honor.
The proof of service is signed by her, right?
It would be electronically on her phone through the application with the company that she has. And so again, as I've stated, she's learned from this. She understands, even if with anybody else was not proper, but it could have been where you just check the app that you did it, and you didn't even leave your home or come down to try to affect services. And she's accepted the responsibility by entering into this delay that she knows that it was not proper, and we're not making any excuses here, Your Honor.
Well, it sounds like you're saying she's not technically guilty of intentional tampering with evidence.
Not at all, Your Honor. I would not do that.
Just making a mistake about what the court rule requires is a different thing entirely from felony tampering with evidence.
Well, and then I think the court is not hearing or is misunderstanding. I'm just trying to explain the circumstances or the facts around that, but I'm not making any excuses, Your Honor. I think it's important for the court to know the totality of the circumstances. That's all. Again, we've accepted the responsibility. We're totally going to comply with the delay period.
Well, I'm wondering whether she should get a delay, honestly. So I'm wondering a process server that intentionally falsifies a proof of service with a court. That's what she's convicted of.
Yeah.
Somebody that does that, in my mind, ought to go to jail. So that's what I'm thinking about.
Your Honor, I don't believe this is the case that would warrant that. I definitely understand the court's concern. I do. But I'm not trying to make any excuse for the client right now. No.
All right, I can tell you there's no way I'm doing a delay.
The judge gives Abbott a chance to speak on her own behalf before sentencing. What follows is a moment that visibly frustrates the court. Rather than owning the intentional nature of her crime, which is what she was convicted of, Abbott uses the word negligent. The judge stops her cold.
All right, Ms. Abbott, you don't have to make a statement today. Is there anything you want to say or no?
Yes, I would like to sincerely apologize for being completely negligent.
See, okay, okay, hang on.
Yes, sir.
You're not convicted of being negligent. Now, you pled no contest, so I can't force you to make a statement about this. But I'm not going to sit here and let you... You're convicted of intentionally tampering with evidence. You're not convicted of negligence. So let's start again.
I was incredibly naive, and I did not understand how to do my job at all. I didn't understand how to be a process. Okay, so I just want to say something.
All right. Ms. Goodrich, any recommendations from the people?
The prosecutor, Miss Fitch, now lays out the victim's side of the story, and it raises serious doubts about the defense's explanation. 2 people had complaints filed against them in court and were never actually served. They only found out because they happened to be able to prove they were at work at the time. No one at either household was handed any paperwork. The story Abbott's attorney is telling simply doesn't add up.
Yes, Sharon, thank you. Here as stated, 2 victims had come forward on June 4th of 2025 to report perjury complaints stating that there was proof of service filed with the district court where they were not served. Fortunately, they both were able to prove that they were at work at the time. What's confusing about the explanation here today is that the explanation that the defendant has given is that she handed it to someone else, but that's not in the PSI description of the offense. And in fact, it says that neither of the people had cameras at their house to see if a process server was at their residence. So it'd be strange that nobody at their house would tell them, hey, I got this paperwork here today, if somebody else was actually served. So I would guess that no person was served at either household based on those set of facts. The defendant is 36 years old. She has no prior felonies and 1 prior misdemeanor. Looks like she's part-time or sporadically employed and has a bachelor's degree. The guidelines are 0 to 9. The plea agreement was for the 6-month delay. The PSI accepts that with a focus on services being for mental health treatment for the defendant, as well as using her positive family support system more so that she makes better decisions in the future.
Now comes the moment everyone has been waiting for, the judge's ruling. And it is one of the most direct, clearly reasoned sentencing statements you will ever see from a bench. He doesn't just announce a sentence. He explains, in plain English, exactly why what Abbott did was wrong, why it matters to every citizen, and why he refuses to simply let it go with a delayed sentence and a dismissal.
All right, thank you, Ms. Abbott. If you please stand for the first sentence. All right, Ms. Abbott, I don't buy a thing you're selling me today. You know, if what you're saying is true, at the end of what I'm going to tell you, you should withdraw your plea and go to trial and get acquitted. Because if what you're telling me is true, I don't know that that's a crime. Making a mistake at your job is not a crime. I probably did it today already. You're convicted for certifying as a process server, certifying that someone was served personally when they weren't, and submitting something false to a court. That's a very serious crime. It's a terrible breach of trust. It undermines the legal system to the harm of litigants. You wouldn't like it today if I sentenced you and you weren't even here and didn't know about the case, because you're entitled to due process of law. The bare minimum of due process of law is notice and an opportunity to be heard. By your lies to a court, you deprived one of your fellow citizens of notice and an opportunity to be heard. I think that's a pretty crummy thing. You have no prior felonies, one prior misdemeanor. I don't really see a need for services on probation. It's really nothing that connects to this behavior of any like criminogenic needs, that would have contributed to this situation. I certainly don't think that kind of behavior warrants 6 months of a delayed sentence and a dismissal at the end. So again, either you're innocent and should go to trial, or if you're guilty, this would not be a just outcome.
The judge announces a sentence that goes beyond the plea agreement, triggering a critical choice for Abbott and her attorney. Accept the sentence and go to jail for 6 months. Or withdraw the plea, go to trial, and face 2 counts of obstruction of justice and 2 counts of evidence tampering. The defense huddles. The decision takes only minutes.
So it'd be my intention today to sentence you as follows. $68 in state costs, the crime victim's assessment of $130, court costs of $350, comply with DNA testing and pay a $60 fee, and serve 6 months in the Sheboygan County Jail with credit for 1 day previously served. That does not comply with that is within the advisory guidelines. I think even though it's an intermediate sanction, the circumstances of this crime, the breach of trust, and the interference with the administration of justice are inadequately taken into account in the guidelines. So therefore, that does not comply with the sentence agreement. So you've got a choice to make, and I'll give you a minute to talk with your lawyer about that. You can either accept my sentence as I've announced it today, or you can withdraw your plea, and it goes back to a pretrial posture, and we'll schedule the jury trial on 2 counts of obstruction of justice and 2 counts of evidence tampering. So I'll give you some time to talk with him. If you'd like, I can pass the case, and I would just direct you to tell Ms. Abbott she may not leave the 2nd floor of this courtroom and this courthouse until we address the matter. Yeah, but you can go out in the hallway and talk. Okay. All right, and I had announced a sentence beyond the terms of a sentence agreement and given her some time to talk with you about her options. Do you know how she wishes to proceed?
Yeah, we would like to withdraw our plea at this time.
Okay, Ms. Abbott, your plea will be withdrawn, bond will be continued, and we'll schedule this for a docket call for, let's schedule this for next Tuesday, June 9th.
That's a problem. I can let the court or prosecutor know.
Yeah, but don't wait for the mail. It's just next week. So I know the mail won't get to you. So next Tuesday, July 9th at 1:30, Ms. Abbott, you can appear by video as you have previously. And we'll, at that date, schedule it for a trial if we need to.
Brittany Abbott walked out of that courtroom without a sentence, for now. By withdrawing her plea, she avoided 6 months in jail, but now faces trial on 4 felony counts. The outcome of that trial will determine everything. What this hearing made clear, however, is that the court takes false filings seriously, because due process isn't just a legal term. It's the guarantee that every citizen will know when they're being taken to court. When a process server lies about that, real people lose real rights. And as this judge made unmistakably clear, that is not something he is willing to overlook.